All right, I guess we will call then the case of MARIANN HUDSON-MCCANN versus Lawrence McCann.
Good morning. May it please the court, I'm Jim Dressler. I represent the appellant wife, who is the respondent below. This is an appeal from a final judgment dissolving the marriage of the parties. We have raised 4 issues on appeal. I'm going to limit my argument this morning to the question of primary residential responsibility for the minor child of the parties and rely on our brief for the other 3 issues.
Counsel, I looked at the final judgment that was rendered by the judge in this case, and then I compared that final judgment to your statement of the facts within the brief. Did you address the factual findings, all the factual findings made by the trial court?
With respect to addressing those factual findings, I did not address all of them for the reason that essentially what the judge appears to have done in this case. My point is that the poll star in determining custody of a child in the state of Florida has always been the best interest and general welfare of the child.
Well, that's fine, but we are not in a position of reweighing evidence. You understand that.
I understand that, Your Honor.
And so when facts are found by a trial judge, if there's competent substantial evidence within the record to substantiate those facts, then we don't go behind those determinations. The trial judge in this case found, for instance, that your client was engaged in parental alienation. Is there competent substantial evidence to support that finding?
I don't necessarily think so if you review the whole record, and that's my point. When you sit as an appellate court in determining whether or not there's reason and logic behind what the trial judge did, you have to review the entire record. Essentially, what the trial judge did here was say that the wife is a vindictive woman and essentially punish her.
The facts are interpreted on really favoring the party that prevailed below.
I agree, Your Honor, but I think you have to look. For example, when the legislature established the criteria under 6113, it's significant that they said that the court should consider all of these elements in making a decision as to who is going to be the residential parent.
And isn't the very first factor that the legislature placed within the statute who's going to allow the other parent access and to allow the other parent to be a parent? Isn't that the first?
That's the first one. However, it's significant that the legislature did not require the court to make findings, and the appellate courts have said it's not necessary for the court to do so. In my brief, I'm suggesting that 6113 and those elements set forth thereon do not change the basic law of the state. Now, the question is that sufficient in and of itself? Because the trial judge found that both parties had fitness issues here. And essentially, if you look at what the trial judge had available, the trial judge appointed the court evaluator to evaluate both homes, and the court evaluator made certain findings based upon her evaluation of both of these homes. The court had that information available, and based on that information, the court held an emergency temporary hearing and changed the original granting of temporary visitation to the husband.
And apparently regretted that decision after the final hearing.
Well, that's the point. The judge, for example, made that decision in November of 2005, and even though the record on appeal shows that there were numerous motions to change that, the judge never granted the husband overnight visitation for a period of 22 months until such time as he entered the final judgment. And the trial judge himself said The question of custody here is troubling because both parties have fitness issues. If you look at the psychosexual evaluation that was done by Dr. Riebsheim told the trial judge in that report and in his testimony that there are problems with the husband here with respect to his sexual proclivities. And he explained to the trial judge that under the circumstances, the husband here may rely on his emotional condition to seek the child's support. And essentially the child had no relationship with the father because the facts here establish that 6 months after this child was born, the father took a second job. He went to work at his morning job before the child got up. He got home about 4:30, was home for about a half hour, went to his second job.
The question isn't whether we might look at this case and go a different direction. That's not the question. The question is whether there's competent, substantial evidence in the record to substantiate the trial judge's ruling.
And whether or not the judge's ruling comports to reason and logic. And I don't think you can overlook that. And that's what I'm trying to point out here. The trial judge essentially determined custody based on whether we're going to reward a good spouse or punish an errant spouse rather than using the best interest and general welfare of the child. I know that's what the trial judge found. However, when you look at this, you have to look at the entire record here. And under the circumstances, and it seems strange, and I brought this up on my motion for rehearing. If you look at the final judgment, and this especially was strange to me, the trial judge says that the petitioner husband shall serve as the primary residential custodian for the child. Now listen to this language. Condition upon the petitioner husband arranging for a Florida licensed psychologist to provide counseling to Megan for 6 separate sessions within 45 days, etc., etc. Then on our motion for stay, essentially what the trial judge did, he said, okay, I'm going to change the time that the wife has to vacate the home until 45 days after December the 1st, and then we're going to address when we're going to change custody after a rehearing. And this record is devoid of any order ever entered changing custody in this case after that 45-day period. So I can't reveal to this court where the child is now because that's the record. However, there's nothing in this record to show that the trial judge has essentially changed custody of this child. Now, I asked the trial court to explain, well, condition, what happens if the psychologist said that this child should not be transferred? Did you, in fact, delegate your authority to the psychologist to make this decision? I think the language was strange under the circumstances.
Well, I think the language is pretty clear that he finds that the best interest of this child is to have her reside with the husband.
That's what the trial judge said, but
frequently.
Subsequent to that, Your Honor, he goes ahead and said, conditioned upon. What does that mean?
Well, I mean, I'll tell you how I interpret it if you're interested in that. It seems to me that neither parent here was perfect.
Well,
they both had some serious flaws, and he chose the best of the two.
Well, actually, the trial judge, as I tried to point out in my brief, didn't list any of the flaws that the husband had, and they were serious flaws based upon Dr. Riebsheim's report and Dr. Riebsheim's testimony. The trial judge just ignored that and focused in on what Your Honor said, that it appears that the wife is not going to foster a close relationship between the child and the father. Dr. Williamson, who in effect testified and did a psychological evaluation on the wife, said, well, under the circumstances, because not only the wife, but there had been 4 separate circumstances where different people...
the wife's, I'm not sure if it's a sister's, but in other words, some of the allegations are coming from people in a relationship one way or the other with the wife. And so the trial judge apparently didn't believe the allegations of sexual abuse.
Well, Your Honor...
You have to assume that is the case.
That's not really
what... I think he says that.
That's not what Dr. Riebsheim says in his report. There were allegations in the husband's first divorce of sexual abuse. There were allegations found by the Child Protective Agency concerning what had occurred. So if you look at Dr. Reebsame's report, the allegations of sexual abuse were not limited to the wife and her sister. They came from different sources, and Dr. Reebsame pointed out that it was significant that not one or two, but as many as 4 from different sources concerned the sexual deviations of this father. So when the trial judge has before him there's this report, which is very damning on the part of the husband, from the court evaluator, he has the psychosexual evaluation from Dr. Reebsame, who was very critical of the husband and said nothing about the husband's parenting skills. In fact, there's nothing in this record, if you examine it, that shows that the father had any kind of a relationship with his child. Essentially, I believe that's why the trial judge said, conditioned upon the husband going ahead and having these psychological counseling sessions with his child.
But wasn't the father having daytime visits with his child on a regular basis?
He was having daytime visitations, and that, as I said, for 22 months, the trial judge had heard all this evidence and didn't make any change. He prohibited any overnight visitation based on what Dr. Reebsame said in his report. Essentially what Dr. Reebsame said.
Didn't both of the psychologists suggest that the husband have submit to a polygraph to put these matters to rest?
Both psychologists did, and the husband never submitted to a polygraph test. In fact, Dr. Williamson said the wife probably was more concerned, and her concern would have been alleviated had the husband undergone this polygraph test. Dr. Reebsame said that this psychological evaluation did not include the use of a polygraph examination. Giving Mr. McCann's deceptive approach to this assessment, it is strongly recommended that he undergo a polygraph examination focused on Mr. McCann's potential for sexual deviant behavior.
Okay, as to the husband's, the psychological, didn't it relate more to his problem with boundaries as to where certain matters should be dealt with children as opposed to adults?
Well,
rather than actual abuse so much as boundary issues such as showering with the children, both his son and the daughter, but these were boundary issues. There was not specific abuse that was that they were looking at, but more the boundary situation.
Yes, Your Honor. In fact, what Dr. Reebsame said in his report and in his testimony, he can't rule out sexual deviant behavior, and he can't say there was. Under the circumstances, the husband admitted to him that he had showered with a child and had the child wash his private parts when they were 3 years old. This child was 8 years old at the time of trial. But under the circumstances, when you have both psychologists testifying, I mean, the court appointed these and asked them to do these. And if you read Dr. Reebsame's report, there's not one positive factor in that report that would support the award of custody to the child. Dr. Williamson's report said the mother, with her shortcomings, is a warm, caring person and is closely bonded to this child.
Well, what's our standard of review?
The standard of review is a breach of discretion, and I understand.
And what's the definition of an abuse of discretion?
Whether or not two different people could arrive at different views on the same subject. Essentially,
actually, I think it's tighter than that. I think in Canacris versus Canacris, the Supreme Court told us that abuse of discretion means whether any other reasonable judge would come out with the same conclusion.
But then again, subsequent to Canacris, then the courts came along and said that the reasonable test also includes whether or not there is logic and justification for the result. And that's what I'm trying to point out to Your Honor. Essentially what happened here.
What case is that?
Pardon?
What case says that?
The case says that's Kuvin versus Kuvin.
Spell it, please.
Kuvin versus Kuvin, 442 Southern 2nd, 203.
442 doesn't sound like it came after Canacris, but okay.
Canacris was 382 Southern 2nd, 1197. They also said that in the Canacris cases. I pointed it out in my brief. But again, in the Hamlet case that I've cited, the court there said, and that's a Florida Supreme Court case again, when you review a judgment of a trial court under the reasonableness test, this court must look at the record as a whole, not just at one element. And again, I suggest to the court that the reasonableness test really requires reason and logic and competent substantial evidence. Now, the judge did make the necessary findings here, but is it based on reason and logic? And that's our position, because the husband really had no relationship with his child. And that's why the court required the counseling. The husband, there's no one that testified that they had any knowledge of the husband's relationship with his child. All of the husband's witnesses said they saw the husband with the child maybe during one time or two times under the circumstances. They never visited in the home. They never had any relationship. But under the circumstances, the court essentially, as I read the case, found because the court allowed this mother to have the child and didn't grant the father any overnight visitation for a period of 22 months, to me that's pretty significant. And when the judge himself said, this is a troubling issue for me, to look at the case and say, because the mother is not likely to foster a close and continuing relationship with the father, I'm going to essentially grant the father custody of this young child. And under the circumstances, when do we change custody? And as I said, the record doesn't indicate that custody has ever yet been changed. And here we are in 2008, and this judgment was entered over a year ago.
There's been no supplement to the record for us to know one way or the other.
No, but I'm saying the last thing in the
Counsel,
record
Counsel,
indicates
you have
that the
about 3
judge
minutes.
would...
You have about 3 minutes.
I see, Your Honor. The judge would readdress this, and there's nothing in the record to show that the judge ever did readdress it.
All right. Thank you.
You have about 2 minutes and 49 seconds left.
Good morning, Your Honors. I'm Susan Erlenbach, and I represented the appellee, Laurence McCann, in the court below. And rather than rely on anything specific, I'd like to answer any questions you might have of me.
Yeah, I want to know where you think the justification for the $2,000 a month imputation of income was on the wife.
Yes, sir. That would be based on the work history of the wife, which was sporadic in the marriage.
When did she ever earn $2,000 a month?
She earned $13.54 an hour at one point.
But that wasn't the answer to my question. When did she ever earn $2,000 a month? When did she ever earn $24,000?
$13.54 was part-time work.
Yeah.
Right.
It was not full-time, so it would not relate.
I believe that the court believed our position that she simply refused to work full-time when she could have worked full-time, that she was capable of making $13.54 an hour, and that she simply wouldn't try.
Is there evidence of that?
Sorry?
Is there evidence?
There was evidence.
You argued it doesn't make much sense. It doesn't make a lot of difference.
Okay. Your Honors, there was evidence that she had jobs that she would stop working and stay off work for a significant period of time simply because she chose not to work again. That was the evidence. My client testified concerning that, as well as the other evidence.
Was there of a specific source for this income as of the time of the final hearing?
At the time of the final hearing, she had been accepted to work in the postal system, and but she simply had put off taking that job because of medical issues, which were resolved by the time of the final hearing. But she still didn't take.
Didn't she then have a physical where high blood pressure excluded her from the employment?
her complaint was that she had a thyroid issue that they thought was cancer, but that was resolved by the time of trial.
Right, but then she appeared to have high blood pressure, and that was an issue that prohibited her employment with the Postal Service?
I don't believe that she, other than her own testimony, that she ever presented any evidence, Your Honor, that the post office wouldn't accept her because of that. She herself alleged that. But
you're the ones that are trying to impute the income.
Sorry?
It's your burden.
I understand. And in our position, Your Honor, was that because of the medical assisting that she had done and her certificates in phlebotomy and her other certificates, that she had the ability to make that level of income.
What was the source of that? As of the time of the final hearing, what was the source of that income going to be contained within this record on appeal?
As of the time, it would have been a position in the medical field based on her certificates, her...
Nothing specific, just a general, we think that she can do this.
Hadn't she sent out...
Based on history, too.
Hadn't she sent out 250 applications to medical providers in the area seeking employment in those areas?
That was her claim. She also had a job that she only kept for a week with a podiatrist, and because she was job hunting on that job, she lost the job.
Now, the alimony award in the case is not being challenged. Is that correct?
My client's not challenging the alimony award.
And
Yes, sir.
you agree that that's a bridge the gap alimony?
Yes, sir.
Right.
Yes, sir.
And the finding on attorney's fees, at the time of the final judgment, the wife has no income and the husband has certainly more than no income. He's employed. How does their substantiation of the judge's finding in terms of attorney's fees?
Your Honor, the judge left my client with all the marital debt. I would concede that there's some question there, but I think that the overall financial situation of these parties was somewhat poor, and that was aggravated, and I believe the court alluded to that, by the wife's behavior in, for example, not cooperating with the sale of the home. The home was a big burden for the parties. The wife wouldn't cooperate with the sale. The court agreed that the only way to ever accomplish the sale was for the wife to vacate. She had not cooperated. And I believe that the judge looked at the overall equities of the situation and decided that it was appropriate for her to bear that burden.
Now, on the primary residency issue, you've got reports that are very disturbing as it relates to your client. And so there's a suggestion that your client take a polygraph exam to alleviate those concerns, and your client apparently never does so.
Okay. Well, Your Honor, I believe the testimony of my client was that he, in fact, took a polygraph test at the time that the allegations...
He couldn't remember who did it, you know.
Correct.
Yeah.
All those records were with the wife in the home. He couldn't locate those records.
So he was asked to take a polygraph exam and wouldn't do it.
Well, Your Honor, with all due respect to everyone who makes that suggestion, I mean, polygraphs are not even admissible in the court system. So why would I...
You want the answer to that?
The reason he would do it would be to relieve the wife of her concerns about the children, and that was the reason it was stated by both of the psychologists. Right. Not that it would be admissible in court, not that it would have any effect necessarily in court or be evidence, but that it would provide the wife, who had, according to her psychological evaluations, serious concerns about his behavior with the children, which she was looking to be satisfied on. She had, in fact, hadn't she defended him at the time that her sister made the allegation when they were about to adopt her niece.
Right.
So she had defended him. She had not always been against the husband, and had not made every one of these allegations as found by the trial judge.
Well, and in fact, I think that affected her credibility in terms of the court, that in fact she never jumped on the Larry abused our child bandwagon until she was faced with his petitioning for custody in this case. She never had alleged that before.
You're getting away from the issue as to the failure to take the polygraph.
Your Honor, all I can tell you is that in the course of this action, my client has had to fight for every scrap of time he's had with the child. He's expended significant monies. In terms of the cost of the cost of the polygraph, I guess would be one issue, and just the inadmissibility of the polygraph would be another issue. Beyond that, I can't give you an answer. That's the answer. That's what.
So you're left then with these reports that appear to be very damaging to your client.
You're left with the innuendo of these reports, Your Honor. However, you're left with no evidence that, in fact, my client ever did anything inappropriate. And if I have to dispute what Mr. Dressler said, we provided significant evidence of the relationship between the child and the father, significant evidence of him spending time with the child. Yes, his time was limited because he worked 2 jobs, but that there were weekends and family outings and times. His son Joey testified about those. The tutor in the home, who was in the home on a weekly basis, saw his contact with his daughter, saw the inappropriate contact of the mother with the daughter, how harsh the mother was with the daughter, how interfering the mother was with the tutoring process, and so had many things to say. We're not talking about the limited evidence that counsel's trying to suggest. There was significant evidence of the bond between the father and the daughter, which of course was disrupted by the mother's inappropriate and false allegations.
I have a question about the mother's interfering with the father's contact. Did the father not exercise all of the contact by the court that was given by the court?
There was evidence of many times that the visitation was canceled by the mother because of alleged sickness of the child, or just simply not cooperating, not agreeing to provide the child, or not providing the child when she was supposed to. There was evidence of that the court took into account. And I would agree with your honors that Judge Jacobus was in the unique position to observe not only the demeanor of these parties, the way in which they did or did not follow his court orders throughout the case, the way in which they conducted themselves throughout the case, but he was in the position to observe the credibility of the witnesses. And the most distressing thing to me, and it comes through, I think, in my closing argument, that although the wife raises all this suspicion and innuendo, she presents no evidence at all at trial that there had ever been improper contact between my client and his daughter. She presents no evidence of that. She has her chance to do this. She presents nothing.
Well, wasn't the psychological testimony submitted?
The psychological testimony establishes nothing except that there was an allegation in the past.
Well,
that was
not an allegation, but a series of
allegations. Some allegations. But if you go back and look, and again, I do want to call the court's attention to this. Mr. Dressler suggested that there were allegations of sexual abuse or sexual improprieties during my client's first divorce. My client was the custodial parent of his son after the first divorce. He was the custodial parent. He remained the custodial parent. That child, who's now an adult and in the military service of the United States, came and testified concerning his dad, and not only his dad as a parent to himself, but how well his dad shared him with his mother, who had problems, but in addition, how well his dad parented his sister Megan, and how inappropriate his stepmother had been, both in terms of her physical abuse of him, as well as her inappropriate conduct toward their sister Megan, and her physical abuse of the father in the presence of the children.
But wasn't there testimony that the father and this child, up to the age of 7 or 8, were still showering together?
Actually,
and that was what the psychologist talked about in terms of boundaries, that even if there was an overt sexual activity, that these were serious boundary issues that this man did not seem to appreciate.
Okay. With regard to any specific testimony concerning my client showering with his 7-year-old daughter, no, ma'am, there was not.
The son. And the son admitted to it in his testimony.
Okay. I'm sorry. I mean, I think I'd remember that. Maybe after pool showers or after the beach showers.
No,
I don't remember any kind of...
When he needed comforting, he would go into the shower and shower with his father. And the psychologist spoke to the fact that these were severe boundaries issues, that adults and children, and when you're comforting a child, going naked into the shower may not be the best way. And in fact, the psychologist found this to be a severe boundary violation. And that's what his report said. That's the one that the father presented, and who did 2 separate evaluations of the father.
Right. And I'll you know, if the court remembers that, then the court maybe read that more recently than I did, and I'm sorry, I don't remember that specifically. But what I would say about that is that, notwithstanding that, and, you know, you have families who go to nudist colonies in this state who think that there's nothing wrong with that. Notwithstanding those issues of sensibility and boundaries and everything, this trial court heard all of the evidence. Judge Jacobs heard all of the evidence and had the opportunity to weigh the credibility of the parties and consider the demeanor of the parties, and to consider, you know, was it more harmful that Joey took a shower with his dad than having his biological mother be called a lesbian and other foul names? Lesbian isn't necessarily a foul name, but be called foul names by the stepmother. Is it inappropriate? Was it more inappropriate for little Megan to be with someone who would stand there in public and rip her father apart, whether Megan, when Megan was present? Is that more harmful to Megan than whatever concerns the judge might have had about Mr. McCann? And this court, and this is a trial court's responsibility. The trial court's responsibility is to look at all of that evidence and weigh it. And the standard is whether any reasonable person could agree with the judge, or if no reasonable person could agree with the judge. I'd submit to the court that obviously...
potential sex abuser versus being critical of the father, and you're suggesting that's a
Your Honor, there's no evidence that my client ever did anything sexually untoward with his child. The suggestions are, the little bit of concern is that there was bathing together. And in fact, if you look back in the reports, the mother and father and child bathed together. We're talking about Megan. Back when she was 3, the mother and child and father bathed together. That it wasn't, you know, we're not talking about something that took place where, we're not talking about sexual abuse. We're talking about parenting. Maybe parenting different than you or I would parent. That isn't sexual abuse. There's all this innuendo and all this, oh my gosh, sexual abuse. But it isn't sexual abuse to suggest that once upon a time, MARIANN HUDSON-MCCANN and Larry McCann decided it was an okay thing to all jump in the shower together with their little girl. And then when she's going through a divorce, suddenly it's not okay and it's a terrible thing and he's a really bad guy. And she's willing to tell everybody in town that he is, including in front of their daughter. And yes, I would submit that it's emotional abuse for her to sit there and trash that child's father in front of the child on a regular basis to anyone who would listen. And that's what the judge found. She did it repeatedly. She did it in front of the barber. She did it in front of the people he worked with. She did it everywhere she could. That's horrible. And that's exactly what the statute puts the issue of sharing the child and co-parenting the child and being willing to. In fact, we know that the legislature is moving closer to the direction of kind of a open arrangements of sharing the children. That's what the legislature cares about, is parents being willing to share the children and not do this alienation and trashing of the other parent. It is so
Don't you still,
damaging.
though, have to look at, for the child, the parent that they look to and have looked to all their life for support or caring for their needs, and that person, even in the psychological, that she could provide that to Megan, and that perhaps some counseling regarding talking in front of the child may be in order, but that she was in fact and had always been the primary parent, the person this child looked to, the person who provided the stability for this child.
Well, but Your Honor, the evidence showed that both of the parties did that my client did that as well.
While he was working the 2 jobs and had Sunday afternoons?
Well, he did work 2 jobs, partly because his wife wouldn't work, and he needed to support the family.
But she was working during that time with a small child plus 2 other children in the home. There were 3 children in the home by the time this child was born. Jordan,
Correct.
son from the prior marriage, and this baby. So he's working 2 jobs. He's home for half an hour and then home at 11, and they're on Sunday afternoons. So who's doing the cooking, the cleaning, the laundry, getting the children ready for school, helping them with their homework, getting them ready for bed, and working a full-time job too?
The evidence...
Is this what we're saying is necessary?
Well, I think it happens in a lot of families, but Your Honor, I'm trying to answer the most important part of your question. And the evidence showed that, in fact, there were significant times when my client spent time with his daughter, that he, in fact, did have a relationship with her, that he did, in fact... I'm
not saying he didn't have a relationship. I'm saying who was the person, at least, well, if we take 7 days, so 6.5 of those days, was the only person providing care for this child in the home, regardless of the reasons. And the court, yes, are the factors favoring the stay-at-home parent? They are. But the stay-at-home parent, or the parent who was there, wasn't that the mother? And the father had not ever been the primary parent of this child, had he?
I don't believe that the court if the court is going to go back to the system...
The question is, was the father ever the primary parent of this child during the time the parties were married and living together?
The primary parent is a term of art, Your Honor, and if you're saying, was he the one who spent most of his time at home with the child? No, he wasn't. Okay? But was he nurturing, loving, caring for her, supporting her, and providing other... spending time with her? Yes, he was. And so I would submit to the court that we're a long, long way from the old days when it's the person who stayed at home automatically gets the child. That's not what the standard is, and nor should it be. But I would submit to you.
Wrap it up.
I know. I'm trying. Your Honors, this judge had the unique ability to look at all of the factors. The court heard lots and lots of testimony, many, many witnesses who testified of the quality of the relationship between Larry McCann and his daughter.
Thank you.
Thank you, Your Honor.
May it please the court, let me just address the question on attorney's fees. The evidence is clear that the husband at the time of the trial was earning $71,069.43 a year. The wife was unemployed. She had applied and passed the test to work at the post office, but failed the test because she had high blood pressure. She also had diabetes and thyroid problems. She had the job that counsel referred to with Dr. Vinotrub. During her lunch break, she was on the telephone trying to get a job on the weekends to show that she really wanted to work. When she was overheard by the office manager, they fired her. Now, with respect to what Dr. Riebsheim found in his report. This is his conclusion. The results of this evaluation provide psychological evidence indicating the existence of emotional and behavioral problems on the part of Mr. McCann, which might contribute to his involvement in inappropriate sexual activity. And with respect to Dr. Riebsheim's report, he notes that Mr. McCann told him that DCF had done an investigation into his alleged physical and sexual abuse of his son. And Mr. McCann says it was unfounded. But this is not something that came up out of the blue. These sexual deviant behaviors were not simply on the part of the wife and her relatives. They came from third parties. And I suggest, as has been mentioned here, that the husband never was the primary residential parent for this child. The wife always had been. Yes, she had shortcomings, but do those shortcomings outweigh the fact that you're taking this child from the parent who has been the parent and who's cared for this child all during her life and putting this child in the hands of the husband who has these sexual problems and never really paid that much attention to the child.
Has the child been living with the husband since the final judgment was entered?
The child has, as I tried to point out in the record, the child has not lived with the husband even up to the time the record was transmitted to this court. And the trial judge made it contingent upon the psychologist, and we don't, it's outside the record. I can't reveal where the child is now, but I'm simply telling this court that as of the last entry into this record, the judge said he would readdress when we're going to change custody of that child after the 45-day period had elapsed. Neither side has submitted any order from the court showing that there's ever been a change of custody.
Thank you, counsel.